It's the Law with Morelli Churtko. Joining me is Ryan Schubert. Family law, personal injury, litigation, estate litigation, these areas of practice for you. And we're going to be talking about protecting yourself after a family separation. First of all, your relationship has ended. What's the first thing that you should do?
Well, there's some preliminary steps that anybody should take. First, obviously make sure that yourself and any children you have in the household are safe. If you need to leave the family house, then do so. By leaving your home, you're not giving up any interest in the property. If there's a safety issue, it's better just to get out right away. And then you should be taking some steps to try and protect your financial and other assets.
Okay, what about protecting your property?
So for protecting your property, usually the biggest asset that you're going to have is the house. So the first concern should be, what is the state of title for the house? Are you on as joint tenants? Is your spouse the only person on the property? If you're not on title, then there's some issues, and you probably should be speaking with a lawyer right away to make sure that you're protecting your interest in the house and that your spouse isn't going to try to sell it from underneath you. But there are also some things that most people have. So normally they'll have joint credit cards with the spouse, or they'll have a joint line of credit, those sorts of things. So one of the first steps that you can take to protect your assets is to contact those financial institutions, whether it be a bank or some other institution, and put them on notice of the separation. It's very important that you put them on notice to say that no further credit should be extended. You certainly don't want your spouse taking out money from the property, taking out further money from any lines of credit or Visa credit cards, Master credit cards, that kind of thing, without your confirmation. Generally speaking, most banks are okay, most institutions are okay with just being noticed by this, but it would be a good idea to write a letter, date the letter, and send it to that institution stating that you do not give them authorization to provide any more credit. If your ex takes out any further debt against that credit card or against that line of credit, be responsible to the institution later on. So you basically want to stop them from doing anything with joint debts.
I imagine that happens quite a lot, that people do not take those precautions right away, and you can run into a lot of problems and trouble that, I imagine.
Oh yes, I've certainly seen many circumstances where 2-3 months down the line, the person's coming to my office saying, I've just realized my ex, took out another $20,000 in the line of credit after we separated. And then it becomes a bit of a tracing and chasing game trying to get the money back.
Okay, that's on credit. What about a joint bank account that you're both in on? So
joint bank accounts, if there's any funds that you have in an account, the first thing you should be doing is to make sure that you stop contributing. A lot of people put their employment checks straight into the joint account, maybe to pay the mortgage, something like that. Don't do that. As soon as you separate, put any further earnings into a separate account. If you have to contact the mortgage provider, then tell them, hey, you're switching the way you're going to be doing payments. You also might consider taking a half the amount from the bank account, the joint bank account. Just if for large amounts of money, if there's more than $5,000 in there, you might think, okay, maybe I'll take half of those amounts out. You want to be a little bit careful about this. You don't want to be seen by the other side to be essentially taking joint property unfairly. But if you take up to half the amount, it's probably not going to become an issue. But you probably do want to see a lawyer if there are significant amounts of money in a bank account.
Right. So thus far, these are all precautions and things you should do. This is before you consult a lawyer. I guess you can do it after as well. But at what point do you go, you know what, I should probably get a lawyer?
Yeah, so once you've taken these first couple of steps, that's when you want to be trying to contact a lawyer. It does take sometimes a couple of days to do conflict checks and meet with a lawyer. So once you've done those first steps, just to make sure you're protecting yourself, now you should talk to a lawyer. The lawyer can go over some specifics in your case, looking at further kind of primary steps that can be taken, such as how do you protect an interest in a house? So like I said before, if there's your spouse, the only person being on title, the lawyer can take out different charges against the property to basically stop them from trying to sell it without your consent. So it basically guarantees you the same sorts of rights as if you had your name and joint title to the property. Other things to be done by the lawyer preliminarily is to look and see if there's any notice that should be given with respect to the payment of child and spousal support. A lot of times people just sit on this issue and then they separate, a couple of years go by, they speak to a lawyer and they say, well, I want all that money that they should have paid me for the last back. They didn't pay me child or spousal support. It becomes a lot more difficult when you're going and looking historically. trying to get those monies back. The courts are more reluctant to grant those sorts of awards. So at least if you put the other side on notice that they do have this obligation, even if you don't have an order right away for them to pay support amounts, then it makes it much easier to get an order later on. And then the lawyer can also look specifically at, is there any issues with the family residence residing in the same? If your spouse is living there and they're not paying the mortgage amounts and you think that's unfair, then the lawyer might suggest having a quick application once a claim is started to seek primary occupancy or sole occupancy of the family residence, so that you're now the responsible party for making sure that the mortgage is paid, because it is a joint obligation as well, but to then have yourself having the benefit of living in the family residence.
Uncomfortable stuff, no doubt, but it's good to have a good game plan. Now, once you've got everything sort of, you got your foundation of how your plan is going to work, what about sort of moving it forward towards conclusion?
Sure. So, again, this is something you can talk to a lawyer about. It's going to depend on every single case. There are many cases that can resolve without even starting a claim. In those instances, the lawyer may be engaged to have some back and forth negotiation with the party or the other party's lawyer, trying to come to an arrangement on a separation agreement, which can deal with all the issues. You can essentially deal with everything by way of a separation agreement other than the order for divorce. The order for divorce, people think that it's more important than it really is. All it's generally used for is to allow parties to become remarried. And you do have to wait at least a year, unless there's some very specific circumstances before you're able to get the divorce order. So essentially everything can be dealt with in a separation agreement. But there are many, unfortunately, cases where parties can't agree, at least at the beginning, and some action has to be taken to start a claim. And there may be having to be a trial on the road as well to have a court determine these issues. Certainly, there are lawyers at Morelli Churko, myself, that can help any client deal with those sorts of issues. And even if it is painful, sometimes that is the only choice to engage in the court processes.
All right, good information. Thanks a lot, Ryan.
You're welcome. Thank you.
All right, there's Ryan Schubert, Family Law. It's the Law with Morelli Churko.